Hi, everyone, and welcome. Um, we're just going to give it just a couple more minutes just to let people get in, and then we'll get going. Well, hello and welcome, everyone. It looks like we've got everyone signed in now. So if people are joining late, that's okay too. On behalf of the Law Society of Nunavut, I really want to welcome Will Collish this morning. He's going to be speaking with us about class actions. And I don't want to take up your time because it's a brief period of time, but just suffice it to say, we're very grateful to William for his time today and very much looking forward to his presentation. So I will leave it to you.
Thank you very much for that. I'll just tell you a little bit about myself and my practice before going into a few points that I want to address with you today about class actions. My name again is William Kolish. I'm a partner at the law firm of Alexis Avocat in Montreal. I've been a lawyer for 11 years now, and the last 8 or so have been focused primarily on class actions. So what I want to do today is give you an idea as to how I got into class actions, what they are broadly speaking, and how they proceed. And I'll conclude by noting the trajectory of class actions in Quebec and the trajectory, we could say, of class actions in Nunavut, although the class action practice here in Nunavut is nascent by comparison. There are potentially some interesting trends that we could look to or tease out from the case law as it currently stands. So to begin with, how did I get into class actions? Well, it was a bit of a surprising practice area for me to land in, given that when I began practicing, I had no interest in them. I probably had some mild antipathy towards them. I ended up in a law firm that specialized in them and also specialized in bankruptcy and personal injury, 2 other areas that I had absolutely no interest in. So why did I go there? Well, it was primarily because of the lawyers. I wanted to work with good, competent lawyers at the outset, and I just wanted to know how practice worked regardless of the area of law that it was in. And this was after a couple of years that I had spent clerking without a clear idea as to what I wanted to do after clerking either. And so really, I was just looking for a good first experience as a lawyer, and it just happened to be in a firm that specialized in class actions. And I happened to arrive at a time, this was in 2016, after the firm where I began my practice had just secured a judgment for $16 billion in a class action representing hundreds of thousands of smokers in the province of Quebec. That judgment was rendered in 2015. And it was in a case that began in 1998, if you can believe that it would take that long to get to trial. But the scope of the trial will give you some idea as to why it took so long. The trial lasted 241 days. It contained over 20,000 exhibits, 70 witnesses, 20 expert witnesses, and the evidentiary record was a little over 250,000 pages in length. So a monumental undertaking. It was a massive case. It turned out to be a lengthy trial with a voluminous record. And after judgment was rendered in favor of the plaintiffs, who were represented by my firm at the time and three other firms, the tobacco companies naturally appealed. And so I arrived sometime just prior to that appeal hearing. And that appeal hearing itself was lengthy and significant. It lasted a week, which is highly unusual, especially for the Court of Appeal of Quebec. It was before a full panel of 5 judges. And the appeal judgment itself took 2 years to render. The result was itself lengthy, like the initial trial proceedings. It was about 450 pages. They rendered it in French and in English, and the judgment rejected the tobacco company's appeal. If you would like to look at the case and have some nice bedtime reading, the citation for the decision is 2019 QCCA 358. And this appeal judgment, it stands, to my mind, as really a testament to the power of class actions to deliver meaningful change for huge numbers of people in one shot, at least on paper. And I say on paper because almost immediately after the appeal judgment was rendered, the tobacco companies filed for protection under the Creditors and Companies Arrangement Act in Ontario, and that put a halt to all legal proceedings against them, including proceedings to execute the judgment that had been rendered against them. So that appeal judgment was rendered in 2019. The stay proceedings began in the Ontario Superior Court in 2019 as well. And since that time, there has been a series of extensions of the stay while the tobacco companies come up with a proposal with the monitor in the CCAA proceedings to satisfy the claims that are made against it. Now we're 5 years after the fact, and still not a penny has been paid out to class members, and not a penny has been paid to the firms that litigated the case. And this is 26 years after the case began. So a bit of a mixed bag of lessons from that case, and in my very first experience observing close hand how a class action may unfold. You can secure these major victories, but what comes after the fact can render those victories appear a little Pyrrhic. So that was in 2019, that Court of Appeal decision. In the same year, I got involved in another significant case. And this was again acting on behalf of plaintiffs, and it pertained to the placement of First Nations youth living on reserve in foster care. And the class period went all the way back to 1991, and it ended up closing the class period in March of 2022. So a fairly lengthy class period. And the basis of the claim was that First Nations youth living on reserve were placed in foster homes at alarmingly high rates because of the way the funding models worked, which essentially were capped for services that could be rendered for First Nations living in their home, but they weren't capped for First Nations children who were placed in foster care. And so there was a perverse incentive for youth protection workers to place children into foster care home. And there was also a component of the case that dealt with Jordan's principle and the unduly restrictive interpretation that the federal government had applied of Jordan's principle, which has essentially resulted in few to none benefiting from that principle. That case resulted in a $23.3 billion settlement, which was approved by the federal court last year. And the parties are working toward implementing that settlement, which will occur over a very lengthy claims period, nearly a 20-year claims period, and will involve some extraordinary mechanisms in order to protect the funds that are available, to ensure that they do not lose money due to inflation over the years, to ensure that claimants have access to all services that they need in order to obtain information about financial literacy, to obtain trauma care, a whole host of ancillary services that come with this settlement. And that settlement, to me, stands as well as an important example of the power and the reach of class actions, kind of delving into areas that were really kind of outside the judicial realm, because this is a unique feature of that case. It came in the context of a parallel proceeding that was started in the Canadian Human Rights Tribunal in 2007. And there was extensive litigation that went on in the Canadian Human Rights Tribunal. It was a case that was started by the Assembly of First Nations, as well as the First Nations Child and Family Caring Society. They were the two main complainants in that case. And the Assembly of First Nations later became a plaintiff in the class action. But the upshot of the litigation before the Canadian Human Rights Tribunal, as well as the class actions, is that there was a companion component, we can say, of the settlement talks. And it wasn't just focused on compensating victims for previous harm, but there was also a long-term reform component, long-term reform of the child welfare system, which was funded to a tune of $19 billion. So separate funding stream available for avoiding future harms, which is unusual. It's not something that you would typically see in a class action, although you start to see more and more frequently that there are injunctive remedies that are being sought in the context of class actions. So that was my part of my initial experience in class actions. It did an exceedingly good job of dispelling any notions that I had of class actions being uninteresting or not a stimulating area of law. To the contrary, they are fascinating, interesting, and important tools for access to justice. So I think most of you likely know what a class action is, broadly speaking. They are cases that tend to group a large or indeterminate number of plaintiffs against one defendant, although they can occur in the opposite direction. You can have reverse class actions in some jurisdictions where you have one plaintiff suing a multiplicity of defendants, but the most common one that we see in the news and that I am familiar with are class actions on the plaintiff side. So question is, why do they exist? Why do we have class actions? And I think one of the best summaries that you can find for that is at the time Chief Justice McLaughlin's reasons in Dutton versus Western Canadian Shopping Centers. And this stands out as a seminal decision that found that class actions do exist at common law in the absence of a complete legislative code. And at paragraph 26 of her reasons, and sorry, I'll just give you the reference for that case as well, which is 2001 SCC 46. So paragraph 26 of her reasons, Justice McLaughlin goes into the reasoning behind class actions, and she writes, the class action plays an important role in today's world. The rise of mass production, the diversification of corporate ownership, The advent of the mega corporation and the recognition of environmental wrongs have all contributed to its growth. A faulty product may be sold to numerous consumers. Corporate mismanagement may bring loss to a large number of shareholders. Discriminatory policies may affect entire categories of employees. Environmental pollution may have consequences for citizens all over the country. Conflicts like these pit a large group of complainants against the alleged wrongdoer. Sometimes the complainants are identically situated vis-a-vis the defendants. In other cases, an important aspect of their claim is common to all complainants. Class action offers a means of efficiently resolving such disputes in a manner that is fair to all parties. So that's a pretty good encapsulation as to why class actions exist. Essentially, you can have one defendant committing harms against a large group of individuals, and how do we pool their claims together in a way that is fair to them, that is mindful of their procedural rights and recourses, but also is mindful of not overtaxing the court system. And so you'll see in the case law, consistently in the case law of the Supreme Court over the years since Dutton was rendered, that there are three main objectives to class actions. One of them is access to justice. The other is economy of judicial resources. And the third is behavior modification, basically teaching a lesson to defendants not to engage in the harmful conduct. That was the object of the case. So that's one way in which class actions can be perceived. Another way that I would put to you, and this is, I think, what allows the mind to kind of focus on all of the procedural quirks of class actions, is that they are a departure, so to speak, of the rule that no one can sue on behalf of another in the absence of an express mandate. For example, in Quebec, parents are allowed to sue on behalf of their children. That's a legislatively granted mandate that allows one party to sue on behalf of another. Class actions are a departure from that rule. They enable one representative plaintiff to come forward and advance the claims of many other plaintiffs, in some cases, millions of individuals who have not signed on to the case, who have not given express authority for that individual to go ahead. And they might not even be aware at all that this individual is seeking to advance their claims in a class action. So because of this departure from the rule that you cannot normally sue on behalf of another person, there's naturally a lot of attention that goes into whether a case should be certified and allowed to proceed as a class action. And that's the first step in any class action, is certification. Does the case meet the test, meet the procedural requirements in order to proceed as a class action? And in one of the decisions that I saw was rendered by the Nunavut Court of Justice in RCP 1 versus Attorney General of Canada, and the citation for this case is 2020 NUCJ 22. The test for certification, as it applies in Nunavut, was described as follows. And it varies from jurisdiction to jurisdiction. So in Quebec, it's a slightly different test. In the federal court, it's a slightly different test, and same thing for Ontario, BC, and other jurisdictions. But in Nunavut, because it's the common law derived test from the case in Dutton, this is how the court described it. And this is at paragraph 9 of the reasons. First, the applicants must establish that there is a cause of action against the defendants. Then they must satisfy the 4 criteria outlined in Dutton. 1, the members of the proposed class must be clearly defined and able to be identified. 2, there must be issues of fact or law common to all members of the class. And 3, if one class member is successful, then all class members must be successful. 4, the representative plaintiff must be able to vigorously and capably represent the entire class. Now, in Quebec, the test is similar in that it aims at satisfying, broadly speaking, the main criteria, but the burden is much lower. It's explicitly described as a very low burden. If we take the first points, the first point that was mentioned in paragraph 9, that there must be a cause of action. Well, a cause of action according to what standard? A balance of probabilities, according to a mere possibility, a color of right. In Quebec, the test is merely that it is possible that the cause of action succeeds. And in fact, it's more specifically stated, it is possible that the conclusions sought flow from the factual allegations made. So there may be simply the mere hope that the class action may succeed. It is not required at the certification stage in Quebec to prove that the case will succeed or that it is likely to succeed. The next point, the members of the proposed class may be clearly defined and able to be identified. In Quebec, it's merely that there is 2 or more people that are part of the class. They don't need to be identified at certification. And in many cases, particularly in sexual abuse class actions, that requirement of being identified is somewhat antithetical to the notion that for many victims, it takes the courage of another person to come forward before they're able to make their claim, and they would rather benefit from the protection of anonymity. So a class member may not be willing to hold up their hand at an early stage of the proceedings and say, I am a victim, I'm also a member of this class. They would prefer, or they may require counseling, support, and a whole bunch of other services in order for them to be able to come forward and claim that they're a member of the class. And they may do so at the very end of the proceedings. There's nothing requiring them to do so at an early stage. Second point, there must be issues of fact or law that are common to all class members. In Quebec, the standard is that there is a common issue of fact or law that is capable of resolving a non-negligible portion of the case. So you need not have common issues that predominate. It need not be the case that class members are similarly situated or identically situated. They may be a part of this case coming from a variety of different backgrounds, having a variety of different situations, but provided that there's one common issue that is capable of resolving a non-negligible portion of the case. I was almost said significant, but that's not the test. A non-negligible portion of the case, and that is sufficient to satisfy that component of the test. The third element that was identified in the reasons that I quoted, if one member is successful, then all class members must be successful. That's not a part of the test in Quebec at all. There's no requirement under that heading, although the commonality component that there is an issue that is capable of addressing a non-negligible portion of the case gets at that point. And then lastly, the representative plaintiff must be able to vigorously and capably defend and represent the class. Again, there, the standard is much, much lower. It's simply that the individual be free of conflicts with other class members, so their position doesn't place them in a position where their interests may be at odds with other class members, that they have an interest to sue, so that they are themselves are a part of the class, and that they have the capacity to give instruction to their lawyers and be involved in the case, but they don't have to be vigorously involved. So that's just a brief comparison between the rules as they stand in Nunavut and the case law in Quebec on the test for certification. Then afterwards, the cases would tend to proceed in similar fashion. So after certification, there's the second phase of a class action, which is the common issues phase. And this is typical of any litigation. You would have discoveries of both parties. You would have expert evidence that is led, and then you'd have a trial on the merits. And then what's different from ordinary litigation in the context of class action is that you have what's called a recovery phase. So that's where individuals who may have until that point had no part in the case. It can be any class member who's done nothing to be involved or even attended trial, sees that there's been a judgment rendered on the merits, and they come forward to make a claim to be compensated if compensation is the remedy that was granted. And that's typically handled through a claims administrator. And these are companies that specialize in the administration of class actions. It's not the case that all class actions require the involvement of a claims administrator, but for larger ones that are somewhat challenging to administer, that's usually to the benefit of class members and really all parties. One feature of class actions that is kind of common throughout the proceedings is the idea of notice. So because class members may not be aware of what's going on with the case, they obviously they weren't required to give their consent to the case proceeding. There's got to be some mechanism in place in order to protect their rights if they don't want to be a part of it. Quebec is an opt-out jurisdiction, which means that if you do not do anything as a class member when the case is authorized, if you don't take any active step to exclude yourself, you're automatically included. I tried to find out in the few decisions that I read for cases rendered in Nunavut whether or not it was an opt-out or opt-in jurisdiction, and I didn't see anything. But there are other jurisdictions, I think Nova Scotia, New Brunswick, where you are not automatically included in the class. You actually have to opt in. That is, you have to submit a form saying, yes, I want to be a part of this case after it has been certified. So notice will typically go out, and this could be via newspaper. Notice could be put up on a website, on social media. Basically an at-large announcement. It actually can go to class members' email addresses too, if the defendant happens to have that contact information. For instance, if you're suing your bank and all the class members are clients of the bank would have their contact information. And so one way of giving notice to class members in that case would be that the defendant bank would be required to send an email or a letter to all class members saying, just so you know, class action has been certified against us. If you wish to, this is what the case is about. And if you wish to opt out, fill in this form and send it to the registrar of the Superior Court. So that's notice at the certification stage, allowing individuals to either opt out or opt in. Class members would also receive notice if there's going to be a settlement approval hearing. So if the representative plaintiff and the defendant agreed to settle the case, that has to be approved by the court. I believe in all jurisdictions, certainly the case in Quebec, and it's the case in Nunavut as well. That has to be approved by the court, and class members need to be afforded an opportunity to express their objections to the settlement if they have any. So notice goes out, class members are informed of the date of the hearing, and if they have representations that they would like to make to object to the case, they would have to notify the parties within a certain amount of time. And so their objections could be lodged, whether it's by written submission or by oral submissions that are made at the settlement approval hearing. Now, as a class member, you also want to be notified if there's money that's going to be paid out, right? So if the settlement has been approved, or if judgment has been rendered against the defendant, and there is a claims process in place whereby you can submit a form and obtain compensation, well, you're going to be notified of that as well. So that's broadly speaking how class actions operate in 3 phases: certification, common issues, and then recovery. And there are slight variations from provinces and territories to the next. But broadly speaking, they all kind of follow that format. I want to talk now about trends in the class action practice, particularly as it pertains to Quebec, but I've also looked at some of the cases in Nunavut, and there are some interesting comparisons to draw out. But before you can get a sense of the trends or get a sense of where the practice is going. I think it's important to look to the history and see how things have evolved to date. So the history of class actions in Quebec is more extensive than any other jurisdiction in Canada, and that's because it was the first jurisdiction to implement class action legislation. That was in 1979 with the amendments to the Code of Civil Procedure. And this came 8 years after the Consumer Protection Act was enacted. So Consumer Protection Act came into force in 1971. The amendments to the Code of Civil Procedure came in 1979. And the reason why I mentioned the Consumer Protection Act is because this is primarily the area that the legislator had in mind when enacting class action legislation. That is, consumer protection was the area of law that the legislator thought this is where class actions are best suited. And this comes at a time in the 70s when corporations had grown in size over the previous decades, and their capacity to harm a large group of consumers in one shot had also grown. And so that's why consumer protection legislation was put in place, to try to balance the forces between large corporations and individuals. And then class actions came as a complement to that, which allowed individuals, the Davids of this battle, to group their resources and take one claim against the defendant rather than many, which may not be of enough value to them to take their cases on their own. The next jurisdiction to enact legislation adopting class actions was Ontario, I believe, in 1992. And then, and I should say, for the first few decades in Quebec, there weren't a lot of cases. I mean, it was a relatively dormant practice, and it's not surprising as to why. I mean, I don't know the exact reasons. I wasn't practicing at the time, but one could surmise that lawyers not really knowing what it would mean, that is, whether judges would be favorable to class actions, whether there was a chance of these types of cases succeeding, would cause some reason for hesitancy. And the other thing that would likely cause some reason for hesitancy is there's no guarantee at the time that you could actually make a living doing it. Because of the class actions, by their nature, almost 100% of the time funded on a contingency model. If you don't really know whether or not you stand a chance of being paid at the end of the day, that's going to cause some resistance, at least within the bar, to really getting behind this practice area. So there weren't a ton of cases that were filed in the initial decades after the Code of Civil Procedure was amended. But then some jurisprudence starts to come out of the Supreme Court of Canada that really endorses class actions as a valuable tool for access to justice. I mentioned the case of Dutton. This was rendered at the same time as decisions in Rumley and Danyluk, two other important class action decisions from the Supreme Court of Canada at the very beginning of the 21st century. And then from there in Quebec, there's also a series of important decisions that were rendered beginning in 2014, and it's continued up until very recently, 2020, all reaffirming the express legislative intent to make this procedural tool available to litigants as a means of accessing the courts where they otherwise wouldn't. So the earliest decision that I could find for a class action in Nunavut is the case of Fontaine versus the Attorney General of Canada, and that's in 2006, which is it's still pretty early on, because Dutton was only rendered in 2001, and that was the first decision which said that class actions can be essentially a common law creation. Not entirely common law creation, because there was in Dutton and there is in the Fontaine decision reference to the rules of the court. So in Dutton, rules of the Alberta court; in Fontaine, the rules of the Nunavut court. And the rule is essentially as follows. Well, I'll quote from the decision in Fontaine in 2006, and this is in the context of the large-scale multi-jurisdictional residential schools class action. So the court states, it is left to the common law and this court's inherent jurisdiction to regulate any proposed class action. The rules provide as follows, and this is Rule 62 of the Rules of the Nunavut Court of Justice. 62 states, where numerous persons have a common interest in the subject of an intended action, one or more of those persons may sue or be sued or may be authorized by the court to defend on behalf of or for the benefit of all. Close quote. So the court in this decision in Fontaine is alluding to the rules, saying that it's not judge created in its entirety. There is some legislative basis. And when you read Rule 62, which is identical to Rule 42 in the Alberta rules of court that were an issue in Dutton, there does seem to be a clear reference to the possibility of taking class action. There's no express term of class action. You don't have the 5-part test that you see in other common law jurisdictions or the 4-part test that you see in Quebec. But there is this idea in the rules that you can act on behalf of another person. Well, now, what I find particularly striking about the decision in Fontaine, and if I didn't give the reference, let me just pull it up. It's 2006 NUCJ 24. What I find particularly striking about this decision is how the court identifies the practical benefits of class proceedings as they're broadly understood by a variety of courts up until that point, but particularly how these benefits match with the reality of litigation in Nunavut and the capacity of the court system. And the court is very explicit about this. I'm at paragraph 50 of the decision. I'm just going to read 50 to 52, which I find interesting and not something that I've seen in case law in Quebec. So at paragraph 50, the court states, the cost of litigation in Nunavut is significantly higher than anywhere else in the country. Air travel is necessary given the distance and geography of the territory. There are no roads between communities. There are no trains or public transit systems. Witness travel costs are a very substantial component of the costs associated with litigation in Nunavut. Lawyer travel also adds to the expense of proving a complex claim in a lengthy trial process. All lawyers presently involved in this litigation are resident outside Nunavut territory. The experts likely to be retained for the purpose of prosecuting or defending these claims are also resident outside the territory. The extremely high cost of litigation in this jurisdiction puts this type of complex litigation out of the financial reach of most Nunavummians. The expenses associated with proving an individual claim would likely eat up any potential recovery in many, if not most claims. The groups most likely to benefit from complex court-based litigation would be the local airlines and legal community. Nunavut is this country's only unified trial court. Its 3 justices are expected to provide all services ordinarily provided by provincial and superior courts in all criminal and civil matters. They also sit in an appellate capacity. All 3 justices are presently working to capacity. This court's lack of judicial resources limits the court's flexibility to accommodate a significant volume of civil litigation. Significant delays in reaching trial can be expected as a result. Close quote. And the court goes on to note that all of this militates in favor of class proceedings existing in Nunavut. They are an efficient way of grouping claims. They are an efficient way of avoiding overburdening the court system with a multiplicity of claims. And they are ways to address the multiple costs involved given the distance between communities, given the travel requirements of lawyers and witnesses, etc. So I found that passage to be particularly interesting because the court there is saying that given the advantages of class actions and given the reality of litigation on the ground here, this is a natural fit. So another part of this case, which I find interesting, if it is indeed the first class action case, and based on the research that I've done, I believe it is in Nunavut, it comes in a completely different context from the one in which class actions began in Quebec. Recall, class actions in Quebec began as a complement to consumer protection. In the Fontaine decision, this class action is the context of residential schools, vastly different type of class action, one that we see more and more common, large-scale abuse claims. But when you look at where consumer protection cases are now in Quebec, they're still being filed at a regular clip, so to speak, but they have fallen out of favor with some critics in the media. Anecdotally, you hear of other lawyers or maybe even judges kind of decrying just how easy it is for these cases to be filed, how much of a burden they place on the court system, and just how, by comparison with the more, you could say, compelling or pressing cases to address large-scale abuse, they can be perceived as kind of occupying a lower priority in the legal system. So that's not the experience in Nunavut, from what I understand. I haven't, conducted extensive research on this, but given that there doesn't appear to be class action cases in Nunavut, one would expect there to be criticism of consumer protection class action cases in Nunavut. Whereas in Montreal, you're looking at a system in that district alone in Quebec that there are, I think in the province, all told, there are 550 active class actions. Huge number. Most of them are filed in the District of Montreal, and there are only 10 judges in the class actions chambers in that district. So broadly speaking, the system is overloaded. Consumer protection class actions are the most obvious object of criticism, which is a bit of an ironic result. We started with consumer protection class actions. I don't think anyone's calling for the end of them, but there's certainly a lot of criticism levied against them. And so that has led, I don't know if there's cause and effect here, but class actions over the years in Quebec have certainly branched out into a variety of areas. They're much broader than just the initial consumer protection cases that one would see. So you see class actions in the area of criminal justice, for illegal detention, failure to respect delays in the criminal code, for the release of individuals incarcerated or detained prior to trial. You see cases in the area of elderly care and old age homes. You see plenty of youth protection cases. And in Quebec, since the statute of limitations was abolished for sexual abuse, there are plenty of sexual abuse cases. So that is kind of, I guess, where we see the trends in Quebec. There's an expansion outside the area of consumer protection. Consumer protection cases still make up, I believe, the last statistics that I saw, about 35% of all cases filed, so still a significant portion. And consumer protection remains an important area of practice, an important area of law. Just because there are many of these cases filed doesn't mean that they're all frivolous. They remain an important means to check the power of large corporations. And one would think in Nunavut, this would be particularly appropriate as well. What I understand, there is consumer protection legislation in Nunavut. Cost of living is notoriously high. And so given that, and given the reasons in the Fontaine decision talking about why class actions are particularly appropriate in a territory like Nunavut. One wonders whether we'd start to see consumer protection cases there as well. So I'll leave it at that. Packed in, I think, a good amount of material for 45 minutes, which leaves us about 15 minutes for questions, which I'd be happy to take from you.
Are you seeing the chat box there? Because there's a
No.
question.
Oh,
Well,
okay.
actually, comment and question.
Okay, let me go there. Um, okay, I see. Okay, are there special risks for the lead plaintiff, such as costs? Excellent question. It depends on the jurisdiction. In Quebec, there are no adverse costs award against the plaintiff. So this obviously removes a significant disincentive that would exist if there were an adverse costs award and potential to be held liable for those costs. In Ontario, there is that risk. There is an adverse costs award that could be faced by the plaintiff if the case is not certified. In federal court, there isn't. In Nunavut, I don't know. Next question. Is there an online database of certified class actions? Yes, the Canadian Bar Association has a database of all class actions filed. So not just certified, but all class actions filed. And in Quebec, we also have our own class action registry. So when we file a case, we have to upload it to both databases. They're not particularly well policed in that you may find a case or you may not find a case. You should find a case, but the case is meant to include, or the database is meant to include, not only a list of the cases, but also who's counsel for the plaintiff, who's counsel for the defendant, what the stage of the proceedings is, and any other procedures that have been filed or judgments that have been rendered. So if the case has been certified, you would hope to see the certification judgment there. If the statement of claim has been filed, you would hope to see that there as well. It would be handy to be able to look up which classes cover Nunavut residents. Agreed. And that might not be obvious from the database, in that in a national class action, and in some cases there are classes that are certified for every resident of anyone who meets the class definition and is a resident of Canada. So you can have multi-jurisdictional class actions or classes that comprise individuals from all provinces and territories. And you would only know that by reading the class definition. Otherwise, the database does mention the jurisdiction in which the case was filed. What is the norm these days for lawyers' fees in a class action? That's a very good question that could take up the rest of our time and maybe a few more hours. The norm, first of all, I should state that the norm at the outset of a case, when a firm is concluding a fee agreement with the representative plaintiff, is that it's done on a contingency basis. So the lawyers are only paid if they're successful, if they reach a settlement, or if they obtain a favorable judgment. there is debate in various courts across the country as to how those fees should be calculated. Should it be a percentage of the total amount of the claim recovered? And if so, what percentage? Should it be based on a multiplier of the time spent on the case? So lawyers are still required to dock their time. And when it comes to settlement approval or judgment, provide their timesheets to confirm the amount of time spent on the case. And in order to account for the risk that the firm takes on, because they don't know if they're going to win or lose or be paid at the end of the day, there is usually a multiplier that is applied to give a premium for having taken on that risk. The range of potential outcomes could be in a percentage-based model, anywhere up to, say, 30% of the total amount of the claim recovered. And it's decided based on a variety of factors, including the result achieved. If it's a very good result, the competency and experience of the counsel that achieved that result. The time spent is a factor that's considered. The extent to which the proceedings were hotly disputed. If you take a case and right away the defendant wants to settle or consents to certification, that's going to diminish your risk. If the defendant is vigorously defending every and all aspect of the proceeding, that's obviously going to increase the risk that you're taking on as a firm, and that would justify a higher fee award. So at one end of the spectrum, you can see something as high as 30% or 1/3 of the case, 33 1/3, whatever you want to call it. Or at the lower end of the spectrum, you could see something in the area of 10%. You can also see a variety of multipliers that are applied depending on the complexity of the case and how it was litigated. And those multipliers, I think, usually go no higher than 4 to 5 times the number of hours put in. And so it's difficult to say that there really is a norm, because each case is decided on its own facts and how it's been litigated. And there's also some variation amongst judges, differences of opinions as to what is the best method for calculating lawyers' fees. Some much prefer a multiplier model. Others prefer a percentage model. So yeah, no easy answer to that question. Okay, next question. In the McLean Indian Day School settlement, I know that there was difficulty finding Nunavut resident lawyers to assist members with the claims process. That process may be finished now, but if not, there is an opportunity for anyone here resident in Nunavut in private practice. And that's good to know. And it's an issue that I believe was also present in the 60s Scoop settlement. I wasn't involved in that case, but I recall reading news articles about, and I don't know if it was the case in Nunavut, but I know in Nunavik, there were many individuals whose opportunity to present a claim simply lapsed because they didn't receive notice of the settlement, and they didn't receive an opportunity to present their claim. And so I believe that there have been applications made to the administrator and even the supervising court to extend the claims period to permit those individuals to make a claim. And so that underscores really the importance of notice, particularly when it comes to notice of settlement approval or of judgment or of opening of the claims process. It has to be as comprehensive as possible so that individuals affected by that judgment are given an opportunity to submit a claim. Okay. All right, I see a comment from Jane O'Neill saying that she's happy to jump in at the end if anyone is interested in updates on the class action referred to in Nunavut. I am counsel, and this is one of the first in the territory. Sure.
Okay.
Happy to cede the floor to Jane O'Neill.
Hi. Just with some sort of breaking news, I guess. Now, the Fontaine case that was spoken about, that was a certification and settlement together, which is often done. Well, in that particular case, there was sort of a national settlement, and they were settling, and they were getting it certified and settled in each of the jurisdictions. The RPC one that he spoke about, we appeared last Tuesday before Justice Cooper for approval of our settlement agreement. We started this one from the ground, and for those that are in Nunavut, you may know some of the council of which I speak. It's historical sexual abuse at certain day schools by an individual teacher. And there were a number of claims started, oh gosh, back in 2003 by Jeff Budden and his team. And they lay dormant for a very long time. And in the end, Button's firm and Alan Regal's firm teamed up, and we're on for the defendants. And because of the way it had been going, and it looked like it would be another few decades before we had it resolved, we actually suggested to counsel for the plaintiffs, because it was and maybe 35 individual plaintiffs, that we agree among us to treat it as a class action, to ask the court to certify it as such, and to follow the rules you would follow in any other jurisdiction. That's what we did. We spent a lot of time explaining to the court so that the court was comfortable in granting our motion to certify, for one, in a consent order on certain liability questions on common issues. That we worked very well with plaintiff counsel, with spending a lot of our time just making sure the court was comfortable in this class action space when it's not one they normally have. We went through doc disclosure, a few discoveries, all that kind of stuff. Eventually, mediation got a settlement. And so we appeared last week before Justice Cooper. We obviously provided notice to the class members, and a couple did show up, not to oppose, but to voice their support for the settlement. And we are now awaiting Justice Cooper's decision, hopefully approving the settlement. And the way the settlement is meant to work is we've got Rice Point, who is sort of a well-known class action administrator, who's taking it over. As defendants, we're paying a lump sum out, an $8 million sum out to them. And there's a claims process that we've asked Justice Cooper to approve that is being presided over by an Inuit retired judge out of Newfoundland. And we've got a short claims process because a number of the class members are elderly or deceased. And we hope to have it, once approved, hope to have the claims process complete within 1 year. So awaiting the decision, she reserved, and so I suspect well, obviously she's going to write something on it. So I guess the message from me is, if you got something that looks like it would be better served in a class proceeding, don't be afraid to do so. The judges in Nunavut were quite receptive to the suggestions from plaintiff counsel and from us as defense counsel on how to resolve That's about it.
And from what I understand, the plaintiff's counsel in that case are class action lawyers. That's correct?
Right. Not really. No. They
Okay,
have done one in the past. Each of them, or one of them has done one in Newfoundland. Yes.
okay.
Yeah.
Okay.
So I'm gonna jump in because I see we're at our time. And I wanted to thank William again for taking his time. We don't, our speakers are giving back to the community of lawyers in Nunavut. We do provide some gifts, but nobody gets paid. So again, thank you so much for your time. And thank you everyone for being so engaged in this discussion. And I look forward to ways that and hope we can continue it in a variety of ways. So thank you again, everyone.
So I know we're out of time, and I saw there were a couple of questions, but I'm happy to leave my contact information if anyone wants to ask questions or discuss class actions further. It's an area of law that I find fascinating, so I'm happy to give more time to discussing it further. So I'll
Terrific.
just put that in the chat, maybe. Yeah.
Great. Appreciate that.